Joining us now to discuss is former federal prosecutor Doug Burns and distinguished university professor at Touro University, Thane Rosenbaum. Thane, I'm going to start with you here. What's standing out for you here? I mean, so many judges, so many different cases. I think for a lot of people who are not right in the middle of it, like all of us are, it's hard to keep track.
You're right, Katrina. Well, look, remember in the D.C. case in Washington, D.C., that judge has already served in the capacity as a judge for 65 other January 6 defendants. So this is her thing. This is her jam. You know, she is not sympathetic to anyone anywhere near January 6th in the Capitol. So you can see that when Jack Smith is looking for a speedy trial, the fact that she won't give Donald Trump's lawyers even additional time to respond to this protection order suggests that she's ready to go. She's ready to go. She's saying, I've already put 65 people in jail. I'll put the president in jail. So that's one way to look at it. Remember, Florida is essentially a red state, and that judge there was appointed by Donald Trump. She already once gave him a favorable ruling when he came before her in civil court, ironically, to protect the documents and give it to a special master. And she's being hard on the government. She's saying, why are you, first of all, it's okay if you want to continue to conduct grand jury investigations here in Florida. Why are you in D.C.? You should not be in D.C. The jury pool is here. This is where you say the crime took place. You say the documents are here. You're saying that he tried to destroy cameras here and mishandle evidence. Why would a Washington, D.C. grand jury have any role to play in further investigations? That's the way to look at what happened the last few days.
Doug, how do these judges get appointed? Because either side could argue that person's not being fair to the president, that person's not looking at it in the same eyes. Is it just luck of the draw, or do you think this is intentional?
Well, there's literally a wheel, and we day-to-day lawyers say, you know, which judge came out of the wheel in the indictment. They spin it. But again, there's a lot of cynicism about that, a lot of insinuation that that was not
Doug,
the case.
okay, Doug, let's assume that it was just random. Certainly right. Qualified. We're not going to question whether they're qualified. But when Chutkan has been connected to the January 6 cases already, can these be reasons for the lawyers for Mr. Trump to ask for a change of judge? Is there any way that could happen?
Well, you have a motion for judicial disqualification, also more commonly referred to as recusal. And the test, the standard is, can the judge's impartiality reasonably be questioned? And you just teed up the fact that you could certainly make some arguments, working off what Thane was saying. One of the tests is, does the judge have a relationship to the case? Does the judge have a relationship to any of the parties? Things like that. So this judge, one could argue, in good faith, has a relationship with the case because of the vast track record of all these 65 defendants. But again, a recusal motion is also an uphill battle. And then there's a very important strategic point on the defense side. And I've been through these discussions here and there over the years. You know, you make a motion to recuse the judge and you lose and you're stuck with that same judge. That isn't so good either. So to answer your question, in my opinion, you could raise grounds to ostensibly question this judge's impartiality, but I'm not so sure I would do it if I were in the case.
Doug, that's, as you said, your opinion, but the former president has a different opinion. Here's what he said on Truth Social. There is no way I can get a fair trial with the judge assigned to the ridiculous freedom of speech fair elections case. Everybody knows this, and so does she. We will be immediately asking for recusal of this judge on very powerful grounds, and likewise for a venue change. We're almost out of time, Thane, but just wrap it up with your thoughts on that.
Well, let's just go for a moment to the D.C. case again. There's some interesting things. First of all, this request for a speedy trial and the order of protection, which would somewhat restrict President Trump's ability to speak, is just so fundamentally incompatible with democracy. Think about what they're asking. Let's rush the case. Let's go. Let's tie the president up with indictments and criminal trials around the country and let him not even be able to speak about it when the underlying crime purportedly itself is that he spoke to the public in rejecting the election results. It is not unlawful to reject election results. Al Gore did it in 2000. Stacey Abrams did it. And they're treating this as if Hillary Clinton said Donald Trump's election was illegitimate. So we're not being intellectually honest. It is not unlawful for a losing candidate to say, wait a minute, I don't feel good about these results. I want to take another look. We've seen it before. But in this case, it is being treated as its own crime that he was not permitted to say.
And in fairness to the other side, Jack Smith would say it wasn't the free speech, it was the actions taken.
But he needed to use speech in order to do that. And that speech is tied up in the conduct.
Fair enough. Thank you, Thane Rosenbaum and Doug Burns. Thank you, gentlemen.